SJC-13147, Commonwealth v. Erickson, Daveiga.
Counsel,
good morning. I think it's still morning. Susan Taylor for Erickson, Daveiga. May it please the court. In this case, the motion judge should have allowed the defendant's motion to suppress the evidence seized as a result of the stop, because in this case, the police had completed their investigation into the stop, which
you've said the stop twice. I have a question, Ms. Taylor. Does the reasoning that you're going to present us with require that the first encounter was actually a stop as a matter of law that required constitutional justification? Or are you arguing it really doesn't matter under Cordero and Torres?
I think that it could be argued either way. I had intended to argue that the first encounter was not necessarily a stop, and only because that is how defense counsel argued it at the motion hearing. So when police drove up and blocked the car in which the defendant was a passenger, there was interaction between.
Well, I'm sorry to interrupt you, Ms. Hill, because that's not my question. I'm very interested in whether the first encounter was or was not a stop, but I have a question before that, which is, does it matter for your reason?
I don't think it does, Your Honor. I believe that when the police interacted that very first time, that when the purpose of that encounter, whether you call it an encounter or a stop, when the purpose of that had been effectuated, when they had resolved the traffic infraction and allowed the men to drive away, that at that point in time, in order to stop that vehicle, they either would have had to have reasonable suspicion or a subsequent traffic infraction in order to stop the car.
Whatever constitutional justification they might have had, your view is it had been fully addressed and they'd been allowed to go on their way. That's your view, right?
Yes. Under Cordero, I think that once the police had satisfied themselves that they had completed their investigation, they had resolved it and allowed the men to drive away, that at that point, they would either require reasonable suspicion or an observed traffic violation in order.
Because the Constitution doesn't have a catch and release program, right? So your argument is that they resolved, either they completed the investigation and resolved it, whether they, and I think Justice Slowey's right, that perhaps it's not a stop, but they resolved what they were going to do. But how do you distinguish those cases where, and they're usually just factual, because I'm not aware of any cases that talk about this catch and release program. But how do you resolve the cases where the police see someone roll through a stop sign, they follow it for a few blocks and they pull it over? They're allowed to do that, right, under the authorization rule?
I believe that they are. I mean, and that's exactly what makes this case distinguishable than most of the stop cases, because even if the police had observed a broken taillight, it continues to be broken for the entire time. But in this particular case, the police had interacted with the men, had resolved the issue of blocking the street, and had allowed the men to leave.
So in the same way, if the police pulled them over, issued a warning, and said, you know, you got to get that taillight fixed, and then let them drive off, they can't pull them over half a minute later, right?
Well, I suppose that's exactly the point. Whether or not there is a requirement that there's some time period, whether it's 2 minutes or 2 days, for a police officer to decide to exercise his discretion under the authorization rule.
Right. And are you aware of any cases that talk about the shelf life of a traffic violation?
No, Your Honor.
But it's not just a matter of time. It's a matter of, okay, there was, whether it was a stop or not. Okay, they're blocking the street. We've dealt with that issue. Torres and Cordero talk about the constitutional justification is only to be able to address the issue. It's not an opportunity to go into a four corners offense.
Well, I think that in this case, the motion judge decided the case on that the police had the ability to stop the car because of the authorization rule. I mean, he premises his ruling on Santana and on Buckley.
Yeah,
But-
I'm necessarily I see this case as a very unusual case, very unusual facts, and whether in the issue of whether it fits into the Torres and Cordero doctrine.
Yes, Your Honor. But I think that this particular case, factually, it presents the court with the opportunity to once again address the issue of pretextual stops. And because at the end of the day, the pretextual stops are
But don't
really—
you win without us doing that? You're asking us to revisit something, and you don't need us to do that in your view to win, because I mean, back to Justice Lowy's original question, it's helpful for you to find that it was a stop because—
Oh, I'm sorry. I didn't know you were the one talking.
Sorry, I know, no one can tell who's talking at this point, but
I go
isn't
through
it,
that with him all the time.
isn't it helpful for you to avoid this issue? Because if there is a stop, it was ended when they started to drive away. So we don't need to go back into the thicket of pretext, do we, for you to win? And do you really want us to go? If it wasn't a stop, it makes your life harder because then it's the second one. I just don't, I'm just not sure you really want to go there.
I would agree that if the court is able to decide the case on the very narrow ground and doesn't need to go further, that's what the appropriate remedy will be. However, I'm prepared to address the issue of pretext stops because in this particular case, the judge denied the motion because his reasoning being that under Santana, that the police officer observing some sort of motor vehicle infraction is entitled to pull that car over.
But the judge didn't address the Cordero Torres issue, right?
No, not directly. No, Your Honor.
The issue is whether what you want to win or win big.
I interrupted you and you were going to make your argument about whether or not the first encounter was a stop.
Well, Your Honor, as I had said earlier, I mean, in my brief, I approached that original stop as a seizure because the police officer blocked the car in and the men would not have been able to leave. I mean, a reasonable person in those circumstances would not have felt free to leave.
But I've read that in your brief and I'm a little bit confused by it because they weren't side by side, right? Wasn't the cruiser a little bit behind such that the driver's side of the cruiser was parallel with the passenger, the rear part of the vehicle the defendant was in? So how would the police cruiser be blocking the defendant's vehicle if it was forward from it?
My reading of the testimony is that they pulled forward to within inches that neither car would have been able to leave without hitting their side mirrors, is how they described it. And the police officer said that he had pulled forward and could only get as far as the rear passenger window. And that is where he engaged the men in conversation.
Right. So doesn't that seem to imply that the car could have gone forward without hitting the police officer's vehicle because their windows wouldn't be next to one another?
Well, but I think that the police officer also said that in order for the men to leave, he backed the cruiser up so that they could freely pull forward.
Might have been a little bit more, it might not have been as precise as that. I thought it was to let them go.
Well, because that goes to, again, Justice Lowy's point, and I guess some of the other concerns about whether or not that was a first stop. And I guess if you say that it doesn't really matter, right? Because they had this conversation, resolved the issue that they had to move and they agreed to move, and so that the whatever underlying authorization rule type infraction was already obviated at that point. But I'd really like to know if you were going to presume that that first interaction was a stop, where does your argument go from there?
At that point, once the men leave, I would argue that given that there's been a seizure, in order to initiate another seizure, a new one, it would have to be, there had to be either be reasonable suspicion that there was some criminal activity, or in the alternative, that they observed another motor vehicle infraction. And I think that the testimony was that they didn't.
They didn't, but to Justice Gaziano's point, it also wasn't that they saw something and waited, because wasn't the testimony that this second, let's just for the sake of argument, call the second stop a stop, that happened like a minute later, that essentially they went down Monadnock, took a left, and that's where they effected the stop of the car the second time, and you're in that argument. Does it matter that it was that close in proximity to the first interaction?
I don't think it does matter. I don't think it matters if it was 20 seconds or 20 minutes, because at that point, the stop itself did not give rise to reasonable suspicion. The motion judge considered the facts that he heard and decided that the fact that my client seemed to be acting out of the ordinary, and the fact that the men decided to continue on down the street rather than parking, was not reasonable suspicion. So in those circumstances, I think that either the police would have had to, in order to effect that second stop, they had to have either reasonable suspicion or they had to observe a motor vehicle.
There's a difference, would you say, if the car had pulled up and the police officer said, "Hey, how you guys doing? What's going on here?" And they said nothing, and nothing else happened, and the car went along its way, and then they pulled it over. But here your argument is that they resolved the traffic issue, right?
Yes.
And then it's over, essentially.
Yes. Now, was there?
But that wasn't a question. That was, I guess, a declarative statement. You have a little bit more time if you need it.
Yeah, actually, if the court is inclined, I also would just briefly like to address the second issue of the admission of what I term to be prior bad acts. In this particular case, the government was permitted to offer testimony from the officer that he had had some 30 interactions with the defendant, some cordial, some not. If you were to weigh the evidentiary value of that information versus the prejudice that flows from it, I think that an ordinary juror hearing that a man in his 20s had interacted some 30 times with police, particularly where I would just, in reading, if I had to read a decision about pretext stops and Santana and Buckley, Chief Justice Budd's concurrence in Long basically sets out that the problem with these pretextual stops and the problem with the information that was introduced against my client about his prior interactions with the police failed to account for the sort of institutional racism that is encompassed in this, all of what we're talking about. So, and in particular, the studies that Chief Justice Budd cites in her concurrence is that Black men are statistically more likely to have multiple interactions with the Boston police. And in these circumstances, and maybe it's the difference between winning big and winning small, but it seems at some point that the issues of pretextual stops, and although in Commonwealth versus Long, the court seeks to address those issues, I don't think that this court adopting Chief Justice Budd's suggestion about a would have test for these types of stops, that it's something that's overdue.
Thank you, counsel.
Thank you.
Sure.
Good morning, Your Honors, and may it please the court, Benjamin Shorey on behalf of the Commonwealth. I think if and I'll address in a moment this whether this first encounter was a stop or not, but I think we just for a moment assume that it was not a stop. And the real question before the court is whether a police officer can take 10 to 15 seconds to make a decision about whether to issue a traffic citation. And I think a rule that would preclude that would incentivize or require police officers to make instinctive decisions as opposed to...
You're missing a step. The step you're missing is, do they get to change their mind, not make a decision? When you roll through a stop sign and they watch a car go down the street and they turn on the blue lights, that's a decision to pull over for the stop sign. That's clear. What is different about this case is the police had resolved, decided not to give an issue a citation. So what's the shelf life of a traffic violation? Is there this catch and release? You get to pull people over whenever you change your mind?
I think, of course,
do your analysis without missing that step.
Well, so if we're going to find significance in the distinction between changing his mind versus making up his mind, I don't know of any case that kind of parses. I mean, the discussion you had about after someone goes through a red light.
It's not.
Any
it's
discussion
more subtle than that. It's I've told the motorist you're good to go.
Well, so I think that gets to whether this was a stop or not. If you look at that encounter, there was never a discussion about it. It wasn't. The nature of the encounter wasn't the officer saying, "Hey, I've decided to warn you. You're free to go." He was very matter of fact. The issue here is I'm physically stopped from going through.
Well, let's be faithful to the record. I mean, so what happens is the officer pulls within inches of the other car. And then the drivers, after some interaction that's apparently odd, despite the, 2/3 of the interactions with the defendant have been cordial. I guess 1/3 have been not. The driver says, "Hey, look, I'll just park right over there." And the officer says, quote, "Yeah, sure. All right, go ahead." So there is this changing of the mind. And then he goes back and talks to his partners like, "Hey, that was odd." So that's this situation. What, in light of that, so do your analysis in light of the full facts of this situation. It's not somebody rolls through a stop sign and then I follow them for a while. It's somebody rolls through a stop sign. I pull up to them and say, "You know what? You're good." And now 20 seconds later, I'm going to pull you over for rolling through the stop sign.
Right. Well, and there's no dispute in this record. I mean, the record is clear that these are plainclothes
so
detectives.
Let's stick to the
this is not
facts and
typical.
how does the legal analysis work?
Right.
Why do I get to change my mind?
Well, I don't know if I understand that there becomes an issue when there's a certain passage of time, but I think that relates to the passage of time between the time they see the violation and the time they
It's not
issue a
about just the
citation.
passage of time, though. Stick to the facts of the case. It's the passage of time plus
The changing of the mind.
Yes.
Right. And I understand your point and Justice Gaziano's point that that's the fact here. I'm not, to be frank, I'm not sure I find a great deal of legal significance in whether it's a changing of his mind within 10 to 15 seconds where he initially declines to issue a citation or initially he takes 10 to 15 seconds to make a decision to decide.
Just in case it is, though, because you started out with an argument about how long does the police officer have to make a decision about a motor vehicle stop? And does it have to be in 20 seconds? And we pretty much already have case law. You're going to win that argument. The problem is that argument's not this case. So I think what we're asking you to do is to, even though you don't think it's a big significant difference, for the sake of argument, if it is a difference, argue that. Argue the change of mind.
So if he changes, I mean, he changes his mind here. And that's, if that first encounter is not a stop, then the fact that maybe to rephrase it, then the issue would be, is an officer bound by their initial instinctive decision when they encounter a traffic violation? I think that's a fair, maybe a restatement of the issue, but so to restate my point, I think it would be bad policy, and I think it would be counter to the reasonableness touchstone of the Fourth Amendment to require that an officer is bound by that instinctive decision. Why
would that be? Assuming we don't agree with counsel that the authorization rule should end, assume the government gets the authorization rule, why should we allow this catch and release, right? Why should we say the authorization rule allows you to pull up to someone and say, hey, you're blocking the street, move it. But I'm not going to give you a ticket. Okay, everything's fine now. And then later on, says, oh, I've got the authorization rule in my pocket. I'm going to pull you over half a block away.
Well, I think...
How is that reasonable?
Well, I think because this initial encounter is not a stop. And so at that point, he has resolved the issue that this...
Right, you're blocking the street, but I'm not going to give you a ticket, move it.
And then he makes the decision too.
Right.
I certainly understand keeping something in the back pocket, but I still think that comes down to, I mean, that might be another case.
So let's use your analysis. If they pulled this car over 20 minutes later, would that be okay?
I don't think it'd be okay. I think that's over the line, but I mean,
okay, let's go backwards.
Anticipating pushing further and further.
Right.
Just, if I can just make my pitch for not reaching that kind of a broad issue, I think the no fix-it statute maybe is the reason why this doesn't come up more often, why it's not an issue. For whatever reason, it's not an issue that frequently comes before the court. And I do think, at some point, following someone keeping a traffic stop in the back pocket becomes an unreasonable.
But isn't this the argument for counsel's point that we should now take on pretextual stops? Because aren't the police officers in this case all but telling you it was pretext?
I think it was definitely pretextual.
Right, but that's what I'm getting at.
Sure.
And in this case, they mined something and they found something. But isn't this the reason why that there's the argument for we shouldn't allow this? You either write the ticket or you don't. Because in this case, they kept it in their back pocket and they had a change of heart because they thought they saw something odd. So they use that a minute later, 2 minutes later, 20 minutes later, whatever it is, as opposed to having dealt with it right then and there. They use that under the authorization rule to pull them over and look in that car.
So I I think that there's no question, and I recognize this, the clear negative consequences from the pretextual rule or the authorization rule. I am, because the court has considered this, and recently my analysis is operating within the authorization framework. I think if you're asking me whether you should change that, reconsider and change that rule at this point, I do think that there are.
But aren't you're pushing us harder to do this. It was one thing for us to justify the authorization rule where you really are, you have a legitimate traffic stop and, you know, they're making a decision about whether to issue it, you know, but once they, as Justice Gaziano points out, resolve the traffic issue, then you're pushing the authorization rule one step further, and making us, you know, you're inviting us to revisit that if you do that.
Well, no, I mean, I think I'm arguing within the authorization rule, and certainly you can, you know, if you find, I'm suggesting that whatever that time span is in the authorization rule, I think 10 to 15 seconds doesn't fit into it, but I get that that's certainly.
Authorization rule authorizes you to stop them because you could give a traffic, and you can issue it, but once that passes, here we've got this factual finding. McDonough indicated to him that doing so was fine and backed up to let him leave. McDonough did not then intend to issue a traffic citation for the double parking. So we're done with traffic at that point, you know. And then if we're done with traffic, then it's the next stop is you know, purely guesswork.
I would say at that point, the issue of him blocking what we have at that point when he doesn't issue a citation is that the issue of him blocking the road is resolved, and the officer has made the initial, perhaps instinctive decision to not issue a traffic citation. So that is established at that point. Within 10 to 15 seconds, he changes his mind much faster than 10 to 15 seconds, because that's the time frame for the actual
But he has no basis for, at the second stop, he doesn't have reasonable suspicion of a crime at this point.
Correct. It would be just based on that. And so that the initial encounter resolves the fact that the car is blocking the road, and then the second or the stop is for the basis of the traffic citation. You know, if the initial encounter is not a stop, I don't see a great difference or any difference between this case if there hadn't been any conversation between the parties and the officer had just been present and seen this violation and decided not to issue a citation and then promptly changed his mind.
You think that the conversation, you're blocking the road, but I'm not going to give you a ticket, inferentially just move it, has no legal significance?
Well, if that encounter is not a stop, I don't see what its legal significance would be here. It establishes.
Well, doesn't it go to the issue of reasonableness, which is the touchstone of the Fourth Amendment?
So, yes, I mean,
so like I get pulled over for speeding, or let's say Justice Kafker does, and that's resolved with just a warning. I don't expect any longer to get pulled over for that.
Well, if you get pulled over, I understand. I mean, at that point, I think it's a stop, and that changes, you know, that changes the analysis somewhat. But
well, maybe that's why this is so unusual, because the officer, without stopping the person because they were already stopped, could resolve the investigation.
And I think I think under that analysis, the purpose of that first encounter is just to resolve the fact that the car is parked in the road, and the second is to issue the citation. And really, when you look at this first encounter, it's not so different from what you would have from potentially from any civilian who is stuck behind a car that's parked in the middle of the road. Hey guys, you're blocking the road. We're waiting for a friend. And then the officer says, I mean, he's said a couple of times, he never gives an indication that he's thinking about giving them a formal warning or a citation. He just says, I get that, but I'm still stuck. And so it's really,
you're in danger of what we've presented to your opposing counsel, winning little and winning big. That you may be getting into losing little and losing big. You push this too hard.
Well, I don't have I don't start with the option of winning big. So
I know you have there's still maybe an option of winning little, but
I mean, the facts are what they are here, and I think I've been quite candid about no one's saying this isn't a troubling circumstance, or the driver wouldn't be very frustrated by the circumstance. But if we're sticking to the legal analysis about, I think
Could we get rid of the authorization rule?
I think the authorization rule is the alternative that I have seen to it that is presented by Justice Budd, I think is problematic for this court to implement, because I don't think that at the bottom line of the reasonable officer test, the would have test, is an assessment of statutes to decide which statutes are intended to actually be enforced and which ones aren't. And I think that's not the place of this court. I do think it causes an Article 30 issue, but in terms of it is something that has happened recently in the last few years for legislatures or other lawmaking bodies, even municipalities, to change the law on pretext stops. And I think that makes a great deal of sense.
But you just gave us a scenario where a few minutes ago you said if this were 20 minutes later it'd be a problem, right? And so this is again, which not trying to hold you to it, but that's what you said. So okay, so if it's 20 minutes later or 2 minutes later, what's the difference? The same underlying concern is apparent whether it's 20 seconds or 20 minutes later, where you let somebody go. You resolve whatever it is, and even under your scenario, you didn't say pull over, I'm going to give you a citation. Hey, move out of the way, I can't get by. Pull over, I'm going to give you a citation for blocking the road. So why does it matter that isn't it cleaner to get rid of the authorization rule? Well, because how are we going to legislate it if you say 20 minutes is too much, but 60 seconds isn't?
Well, in that case, I think the rationale would not depend on what the underlying violation is, and it would be based on the police officer's conduct in that particular circumstance. But I think when you're looking at just the reasonable officer and the would have test, you're looking at what the issue was, whether it was a traffic violation, a minor traffic violation, or a significant traffic violation, how much over the speed limit they were going. And I think that is where you get into the essentially overriding a statute and saying a reasonable officer would look at that statute and say that one isn't really intended to be enforced here. And we all know, and of course the case law establishes, there are minor traffic violations, but to go parsing those and deciding which ones the legislature really means and which ones they don't, I think gets us into a really different territory.
Any further questions? Thank you, Council.